I'm Monica Young. I'm the broker of Just Global Inc. and the host of the GREI Club. For today's presentation, we're going to have two parts. The first part is going to be a market update by our team member. And the second part is going to be our feature presentation by Mr. David Bonaccorsi on tenant ban and on eviction and rent moratorium. So let's start with the market update, please.
Hey, good morning. Just wanted to give you a quick introduction. That was Monica Young right there. She is the broker of Just Global Inc., and we've been in real estate for over 20 years. So if you have any real estate needs, please feel free to reach out to us there. We're going to take a look at the local Santa Clara County market. Big stat that jumps out immediately, you're going to see that the average sales price from year to year has jumped up 17%, while the active listings have dropped dramatically by about 37%. And this, combined with the historically low interest rates right now, have driven a lot of people to come out and look for homes. Just last week, we bid on a Santa Clara home, and we saw that there was over 17 offers. So very hot market right now. And naturally, as a lot of you are investors, we do look for alternatives when the market's so competitive right now. So we look in cities such as Austin, Texas. Now, these are the stats for Austin year over year. And you'll notice the immediate thing that jumps out is that the average price sold has gone up about 20%, whereas the active listings have gone down a whopping 44%. So definitely a very hot market in Austin right now. So why are people so interested in Austin? The main driver is going to be the strong tech economy over there. And the strong tech economy causes a lot of job growth, which in turn creates the population growth. And as a prospective landlord, that's really good for you because that means there's a huge demand for housing. What these jobs create is qualified tenants and stable rental income. So we're going to take a look at some inventory that we've been looking at as far as new construction is concerned. This one's 1440 square feet, 3-bed, 3-bath, with a price tag of $273,000. And as you can see, the projected ROI and 5-year, 10-year appreciation are pretty strong. So if you do have interest in a property such as this, please give us a call or contact us at info@justglobal.net. We will post this on YouTube later so you can review these stats. And what are we up against right now? Time is of the essence here. Since the pandemic started, the lumber cost has gone up about 170%. And this is estimated to increase the price tag of these new construction homes by something to the tune of $16,000. So that, combined with rising cost of other construction materials and a labor shortage, all compound to increase the price tags on these homes. So if you want to buy, it's better to act fast. So without further ado, I'm going to turn this over to Mr. David Bonaccorsi.
Yes. David, you can start. And David has been speaking to our group for a number of times already. And so, David, please update us on the latest CDC ordinance and also the AB 3088.
We're happy to do that. Those events just happened in early September. So anybody that's been to these webinars before is going to get some very new information that's only happened in the last couple of weeks that have some very significant impact on landlord-tenant relations. So if we could have thank you, Monica, for introducing me, and I'm happy and honored to be back at the Global Real Estate Investors Club. I believe this is the third time I've done a presentation, and I've done 10 presentations overall since we've had our pandemic back in early March with a plethora of new federal, state, local laws that we've had to follow. Can we have the next slide, please? There's tenant eviction bans and rent deferrals. We've had a process where the governor initially allowed local control over eviction bans and rent deferrals. the counties and cities exercised that local control. And then the governor enacted a temporary statewide ban that ended on May 31st. He stepped out of it and left it primarily to local control. And then I'll talk briefly about what the California Judicial Council did on April 6th. Next slide, please. So on March 4th, the governor declared a state of emergency due to COVID-19. And shortly thereafter, he enacted an executive order, Executive Order 28, which was the specific authorization to cities and counties to enact and renew eviction ban moratoriums and deferred rent for both residential and commercial tenants. The executive order is set to expire on September 30th for residential tenants due to the new law that passed called AB 3088 by the state legislature. But just on Thursday, the governor extended the authority of local counties and cities to enact or renew or modify their commercial bans and rent deferrals all the way to March 31st, 2021. So that will be for the commercial landlords and tenants out there, there may be some more opportunities and restrictions on evicting commercial tenants, but that would be based on local law, not any statewide law. The legislature never passed any statewide law addressing the needs of commercial tenants as they did for residential tenants. And when I should step back and just before I begin talking about all these restrictions, keep in mind this is primarily a public health driven issue. And yes, as between landlords and tenants, I know landlords are feeling squeezed, but the bottom line is that we do not want to have mass evictions of tenants who are dislocated, cannot find other places to live, unemployment's running out or is not as extensive, and they can't find other places to rent. And so you have all of the people moving around, and that's the kind of event that's going to trigger a new spike in COVID transmission. And now we're also going into the fall where there's a what they describe as a phase 2 with the flu season. So as painful as this is economically for us, the larger issue that the state and the federal government are trying to address is reducing the positivity rate of transmission. Does that make you feel any better? I don't think so, but it at least gives you some of the understanding as to why all of these restrictions are in place. Next slide. Once the governor allowed for local control, those counties and cities have done so. Alameda and San Mateo County enacted commercial moratoria that applied in the unincorporated areas. Alameda County initially applied one that was only applying to the unincorporated areas of the county, but in successive ordinances now apply to every city in the county, including Fremont, Union City, and Hayward that had previously had moratoriums. Santa Clara has enacted countywide ordinances that apply unless a local jurisdiction has one that's stronger. We'll discuss that briefly. But because of AB 3088, we'll talk about the effect that impacts Alameda County differently than it does Santa Clara County. Next slide. So again, there was all of these moratoria that passed at the city levels, and they gradually were usurped or preempted initially by the counties or now by state law. Next slide. One of the things that in all these moratoriums, it was pretty easy to say, well, what the rules are, because even though there were separate moratoriums, separate rules in different cities and counties, no matter what those rules were, even to the extent they addressed evictions, they were enacted in March. But in April, the California Judicial Council came up with a restriction banning all evictions that was repealed on September 1st. And so landlords were at that point thinking, well, we now have an opportunity to get back into court and evict tenants that haven't paid rent. But certain things happen that has now, as you learned today, will severely still restrict landlords from evicting tenants, particularly for non-payment of rent. So we had March, the enactment of the emergency shelter emergency, the executive order by the governor allowing local counties and cities to enact all of these myriad moratoria. But really we were in a deep freeze until September 1st. It was lifted, and then we'll talk about what happened next. Next slide. This has really become increasingly important, and I'm a little bit out of chronology. This was enacted on September 4th. I'm going to talk about AB 3088, which was enacted 2 days earlier at the state level. But because of this residential eviction ban, it's increasingly becoming a dominant regulation that overrides and overwhelms our state law that was passed early September. The big headline is that the CDC, the Center for Disease Control, enacted a nationwide residential eviction ban, and it halts all evictions with some limited exceptions through December 31st, 2020. The tenant has to submit a federal form, a CDC form under penalty of perjury that they are a covered tenant. But the order doesn't apply to state or local moratoriums that provide the same or greater protection or for a breach of lease, criminal activity, property damage, building code violation, or threatening behavior to other tenants. Penalties for violation can range from $100,000 to $500,000 for a single violation and jail time. So the big question today in our seminar and our webinar is, does the state law AB 3088 or in Alameda County, does the county ordinance provide equal or greater protection? And the CDC, and this was cut off at the bottom, but I'll read the sentence to you as to what was meant here. The CDC order does not allow removal from rental markets as a reason to evict a tenant. So to the extent that the state law that passed, and even in Alameda County with its very strict no eviction ban, allowed an exception for somebody that wanted to sell their property to remove it from the rental market, the CDC rule does not have that exception. So in my opinion, as we talk about these other rules, in my opinion, at least through December, you cannot go in to court on an eviction for non-payment of rent for a residential tenant. This does not apply to commercial tenants. This only applies to residential tenants. Next slide. The Alameda County ordinance is the only law now in the county after September 1st, after the California Judicial Commission Council lifted its ban. It applies countywide, and it bans most evictions in the county. The exceptions would be if you have to remove property from the rental market, but as we said just a minute ago, the CDC rule, because it's federal, overrides this county ordinance. If you had to be vacated by a court or agency order, imminent threat to health or safety other than COVID-19. Next slide, please. Here was going to be my highlight of the webinar until we began to see that tenants were really now taking advantage of the CDC rule to try to forestall and create hurdles for evictions, even in California. AB 3088 is the COVID-19 Tenant Relief Act of 2020, or the CTRA. But the Alameda County eviction ban ordinance is still the law for now. AB 308, at least in Alameda County, not everywhere else. AB 3088 passes on September 1st, just as the California Judicial Council eviction ban order expired. The CTRA applies retroactively to August 19th. If the local ordinance was adopted before August 19th, then it remains in effect. Any renewal or extension after August 19th is void until the AB 3088 is lifted on February 1st, 2021. So the Alameda County ordinance was enacted and strengthened in July, but they didn't do anything after August 19th. That's why the county ordinance is still in effect. The Santa Clara County ordinance was renewed on August 25th, and because they acted after the August 19th cutoff, there is no more Santa Clara County moratorium for residential tenants. You have to look now just to the CDC or AB 3088 for the laws that apply in the county. Whereas if you're in Alameda County, you have to look to the CDC and the Alameda County ordinance. For Alameda County tenants, rent is due 12 months from the date due, but the California Tenant Relief Act ends deferral March 1st, 2021. So if you have a tenant in Alameda County that wasn't paying rent in March, then at that point, they do need to pay rent. They can't defer it for 12 months. Unless, of course, the eviction ban still is in effect in Alameda County, so you can ask for rent, but if rent is not paid, you cannot still evict in Alameda County. The law in Alameda County is that the eviction ban for all residential tenants extends 60 days after the county health emergency expires, but not sooner than December 31st, 2020. So if you're in Alameda County, the eviction ban and the limitations on rent collection will continue, in my opinion, sometime through 2021. And then and it's whichever is later. So it's not sooner than 12/31/2020, but it's probably going to be 60 days after the health emergency expires, sometime in 2021. Next slide, please. This is the highlights of the CTRA. And why am I talking about it now that I just told you that the CDC bans all evictions? Because the CDC ends on December 31st. Many of the rules that apply to the new AB 3088 or CTRA expire on January 31st. So you want to get in place all the requirements so that if your tenant is not doing what is minimally required, then potentially by February 1st of 2021, you can proceed under the CTRA and proceed with an eviction. First, it does not apply again to commercial tenants. There's no statewide law apply for commercial tenants, but look to your county or city to see if there's any moratoria that protects commercial tenants. The CTRA does two things. It divides up the timeline between a protected class of payment from March 1st to August 31st, 2020. A low-income tenant who provides a declaration, or a high-income tenant who proves that they've lost income due to COVID cannot be evicted for rent non-payment that became due. So if they didn't pay at all, or they paid less than the amount that was due from that period of time, that can never form the basis of a 3-day notice to pay rent or quit. A high-income resident is defined as somebody who has household income 130% of median income, and they must provide proof of income such as a tax return or a W-2 pay stub to show that they've had a substantial loss of income due to losing their job, or sadly if they have COVID and have high medical expenses. For all landlords, and I know today is what, the 26th of September, so by Wednesday, all landlords are supposed to provide an informational notice to their tenants if they have a tenant who has not paid rent at any point from March 1st through August 31st. Well, how do you get those forms? I hope you become members of the California Apartment Association if you're landlords. And if you're realtors, I found out, and I'm also a member of the California Real Estate Association, there are CRA forms that are now available that you can get. So if you're a landlord that knows a real estate agent, ask the real estate agent to pull down this new informational notice. The notice you can't make it up on your own. You have to follow the statutory language, and so the forms are set. If you're not a member of the California Apartment Association, you should join your local chapter. I believe in Santa Clara County, it's the Tri-County chapter that includes Santa Clara, San Benito, and Santa Cruz. In Alameda County, you want to join the Rental Housing Association of Southern Alameda County, and then there's another one that's further north. So find out your local chapter and join it to get all the forms you need. Now, I mentioned that there was the March 1st to August 31st was one 6-month period or 5-month period where you cannot evict for rent for non-payment. There is now a new period, a provisional or transitional period from September 1st, 2020 to January 31st, 2021, where the landlord cannot evict tenants for rent non-payment as long as the tenant provides declarations and an informational notice was provided to that tenant and, for non-payment, and as long as the tenant pays 25% of the rent. Now, I'm going to be asked questions about this because of we need to talk about it several times to really understand how this works. A tenant is only obligated to pay the equivalent of 25% per month to stay current. However, they don't have to pay 25% in any particular month, okay? As long as they pay the 25% per month cumulatively over a 5-month period, they will preserve the right to stay in their tenancy and not be evicted. So you can go through a process of a 15-day notice each time. If they pay 25% that month, yeah, then they're caught up. But remember, we now have the CDC rule. So effectively, even if they didn't pay any rent at all from September through the end of December, you can't go into court to try to evict them because of the CDC ban on evictions. So the AB 3088 was a standalone law. It was done without the benefit or the impairment of the CDC nationwide ban on evictions, but I would still provide these notices and have tenants provide declarations, and we'll show you the form, because you want to be sure you know which tenants are invoking their protection under this new AB 3088 CTRA as having an impact on their income due to COVID, so you know which ones are entitled to protection and which ones are simply not paying rent and not giving a legitimate reason why not. Next slide, please. Again, oh, that's right. The CTRA is form driven. Again, mandate specific language. So if you try to type up your own notice and you think you're doing it on your own, you want to save money, you're likely not going to do it right. And if you go to court and you're not using the right language, your form is invalid and your eviction will be set aside. You'll have to start all over again. There's also another complicating factor. If you happen to have a federally backed mortgage, the Federal CARES Act still requires a 30-day notice. So what you would have to do is, in combination, is you'd have to give a 15 days notice to cure. It's not a 3-day notice, it's a 15-day notice where the tenant can get caught up for rent past September 1st. But you couldn't evict for 30 days. You'd have to allow them to stay for 30 days. But again, now we got that additional layer of the CDC guidelines that says you can't evict until the end of the year. So the 15-day notice for the notices excludes weekends and court holidays. So if your 15th day ended on a Sunday, they would have until Monday to cure. Again, the informational notice, the CA 400 is the California Apartment Association form number. CAR probably has a different form number that they've created. There is a special form, a CAR form, a CAA form 403 for the rent that's unpaid from March 1st through August 31st. And then again, the separate time frame there's a separate form 410 for tenants that don't pay between September 1st and January 31st. What happens to unpaid rent for non-payment from March 1st to January 31st? I mentioned already that can never form the basis for an eviction. You can't use it for a 3-day notice or even a 15-day notice to pay or quit. It becomes a consumer loan. And they followed what's happening in Alameda County for unpaid rent for eligible tenants. And they makes it a consumer debt. But they've also done something very interesting under the state law. Normally, small claims are limited to $5,000 against individuals or $10,000 against corporations. They've blown the lid off for small claims court. So if you've got a tenant that owes you, let's say, $30,000 over 6 months of rent from March 1st to, and this is right, this is incorrect. This is it's March 1st, 2020 through August 31st, 2020. not January 31st, 2021. That's a 5-month period from March 1st, 2020 to August 31st, 2020. Let's say that the tenant owes you $25,000 of rent. You can go to small claims court. In fact, you are supposed to go to small claims court. There's good and bad about that. You'll be happy that you don't need an attorney, and an attorney cannot represent you in that process. The bad news is, and I think the legislature has set a trap for potential non-payment. The small claims are equitable. They theoretically don't have to follow the law in the small claims court. So a small claims judge could, going outside the landlord-tenant laws, say, well, I still want to forgive this debt and do some self-help from the small claims bench. And if a claimant, if you're the plaintiff as the landlord trying to seek money and you lose or don't get all that you want, you don't have a right of appeal. The only right of appeal would go to the tenant, who could appeal to a superior court for a completely new hearing, and then you'd have the right for an attorney, and the tenant could have a right for an attorney, but that would delay the process another couple of months. So I suspect that when landlords go into court to try to collect back rent, and there's some crazy things that happen in that process, that there's going to be some remedial legislation to allow both sides to appeal, or allow landlords the option of going into regular court and avoid small claims at their option. You can't go in right away. The courts won't be open for small claims until March 1st of 2021. So even if you know today that you have a tenant that hasn't paid or hasn't paid all their rent from March 1st to August 31st, you won't be able to collect on that rent. And then for the period of time, and so I guess I'm right in this sense, there is two time periods. For the 75% of the rent that is not collected for a COVID eligible tenant under AB 3088 from September 1st, 2020 through January 31st, 2021, through that period, the amount of rent that's not collected is then also subject to small claims collection eventually. So that could never form the basis for a 3-day notice to pay rent or quit. Next slide. Last year, the legislature enacted a law that took effect on January 1st. And before the pandemic, Global Real Estate might have invited me just to have had one webinar on the new AB 1482, and that's all we would be talking about if there had been no COVID, because this itself has created a significant change in landlord-tenant law. In cities that do not have rent caps and just cause eviction, for eligible tenants that have lived continuously in their properties for 12 months or more, they are subject and have the benefit of statewide laws to have just cause eviction and a form of rent caps. But this is not an AB 1482 seminar, but I'm going to mention that the protections under the CTRA now apply to tenants that would otherwise be subject to just cause eviction, and they're entitled to the same rights to not pay rent for the past 6 months through August 31st, and then from September 1st up through January 31st of next year, pay only 25% of the rent. One of the just cause evictions that's allowable under AB 1482 is if you want to do a substantial remodel. So I've had a lot of clients before the pandemic say, my client really does want to do a substantial remodel, maybe market it, maybe not, maybe increase the rent that he or she can collect after you've updated the kitchen and put in new new amenities. Well, the CTRA says you can't use that as a just cause eviction rationale. You cannot do that unless it's a habitability requirement, and that would really be very hard to show. You'd have some sort of nuisance claim that the government is saying that there's some misuse of the property that requires you for health and safety reasons to remodel. Unlikely that you'd be able to get it done anyways. But that limitation on the substantial remodel just cause eviction is in place until the end of January of next year. As of September 2nd, 2020, courts are open for just cause evictions other than rent non-payment, and there would be a limited type of claims that you could make now. Let's say somebody even under the CDC rule, let's say you've had a tenant that is using his rental for a meth lab or for prostitution ring, or they violated some other written covenant which is not related to rent, such as subleasing without your prior written consent. Those kind of claims can be a basis for eviction now. AB 3088, the CTRA does allow courts to reopen for non-payment eviction. The tenant hasn't given you a declaration of financial distress or other high-income documentation if they're a high-income tenant. But again, because of the CDC rules, even though the state allows you to go to court, in my opinion, under the CDC, you should not be going to court for mere non-payment of rent. All cases can be brought under the state law after February 1st, 2021, unless the CTRA is further amended to extend these deadlines. Next slide, please. Briefly, I know there may be some commercial tenants here, commercial landlords, so I do want to touch upon that. There are still rules that apply. There's no statewide law. So do you see if the county has if you want to know which law applies, does the county have an eviction ban and allow rent deferral? If so, and the property is in an unincorporated part of the county rules apply. Does the city but not the county have an eviction ban and allow rent deferral? Then follow the city moratorium. If the city and county both have eviction bans that allow rent deferrals, which applies? In Santa Clara County, because it applies county-wide, if there's a commercial moratorium in the city that you're in that's more beneficial to the tenant, that rule would apply. In Contra Costa County, by contrast, they explicitly say we're not going to require the landlords and the tenants to figure out which is more favorable. If there's a city rule in place, follow the city rules. So in Concord, you follow the city ordinances in Concord. If there's no moratorium, then you follow the county ordinance. Next slide, please. The Santa Clara County moratorium is going to continue for small business tenants. I was going to tell you until 2 days ago that both the residential and the commercial moratorium in Santa Clara County was going to end. Not by virtue of anything that the state had done, but they had written their ordinance in such a way on August 25th to say that their moratoriums would expire on November 30th or at the expiration of the governor's executive order 28, which was on September 30th, whichever is earlier. And I didn't think that the governor was going to extend anything, so everything was going to end on September 30th. But because of AB 3088, as I mentioned, the residential portion expired because now the state law controls. For commercial tenancies, at least through November 30th, the county's ordinance will still continue to exist because the executive order 28 goes to March of 2021. I suspect the county will now take full advantage of that deadline and extend its moratorium. Rent for commercial tenants is up to 12 months that they could defer. There is still a notice of termination. There's a notice of termination with notice of tenant's rights. And if tenant is eligible, owner should not terminate a tenancy for non-payment of rent. If they're an eligible small business commercial tenant that can document that they are subject to COVID relief. Next slide, please. Watch for future developments. And we're already and I was right, it's only about 10:34. I told Monica, I promised her that I would only go for about 35 minutes. We got a few forms to show you, but we're ready for questions. Watch for future developments. Waiver by the CDC of California's AB 308 and local residential tenant ordinances that predate August 19th. We need to see something from the federal government that says AB 3088 and California has its own rules. It doesn't have to follow CDC. Otherwise, we're going to err on the side, or I'm suggesting we err on the side of the CDC rule for non-payment. Again, the Alameda County residential ordinance is 60 days after 12/30, or the county public health order is lifted, whichever is later. Writs of possession, even in Alameda County, it's kind of a moot issue right now, but even, well, it's not. If you go in for a just cause eviction for a breach of lease and you get a judgment in November and the tenant's still not out, the sheriff's not even going to try to help you evict that tenant in Alameda County until next year. Fremont commercial moratorium remains in effect 30 days from the expiration of the city of Fremont local emergency. And I'm sure, again, like Alameda County, the emergency for COVID is not going to be lifted until sometime next year. And I mentioned the deadlines for Santa Clara County, and you'll be able to get these PowerPoints and see these slides. Next slide, please. Here is an eviction protection procedure that again outlines in a flow chart the two time periods that I talked about, the rent that was due from March 20th to August 20th. There's one series of things that the landlord can do and separate sets of forms that need to be sent out. And then rent due from September 20th to January 21st, where the tenant must pay at least 25% of the rent, but doesn't have to pay it until by January 31st. You know, if the tenant doesn't return the declaration under the current rule, you could be getting evicting under state law by October 5th. But under the CDC rules, I don't believe you should be going into court for non-payment until January at the earliest. Next slide. Here is the 15-day notice of rent with blank declaration. This is the rent that would be due currently from September 1st, 2020. This was one of the California Apartment Association forms that I showed you, and how you fill it out. And then this is telling the 15 days notice, and you really should try to personally serve these notices, but they are subject to the same rules that you would apply, or if you do a mail and post, then it adds time to the 15 days as it would to a 3-day notice. But personal service assures you that you really got the tenant. And I also would suggest using registered process servers because they're given presumptive right in court that their declarations are presumptively valid. The registered process server has a license, and if they, under penalty of perjury, say they served somebody or whatever the mechanism they served, it puts a higher burden on the tenant to claim later that they weren't served and didn't know about it. Next slide, please. This is just a continuation of the 15-day notice. This was the Form 410 I mentioned about for the period of rent from September to January 31st. Next slide, please. Let's go back, Carl. Let me show you this, okay? Let's go back to one slide. Acceptable methods of payment, okay? Look at all the methods of payment. I would check all of them, okay? Give the tenant every opportunity to pay on time. Don't make it difficult on the tenant if you want to get paid. Next slide. This is another notice. This is the informational notice, I think, that has to go out. And this describes what the new law is. And next slide. It continues on. The financial distress required of high-income tenants. Those are the ones that are earning either 30% of median income. And there is a chart that the California Apartment Association provides for people to show what median income is in the various counties. Next slide, please. This is the declaration, again, of financial distress. This is what the tenant would sign on their end, okay? And again, if you look at the declaration, I would allow tenants to email you the declarations. You don't want to be getting into a contest in court as to whether you got the declaration or not. So give them every possible method of giving you that, the opportunity of giving you that declaration. That entitles them to only have to pay 25% of the rent cumulatively by January 31st. But if you give them email, you give them all these chances, and you have a registered process server said, I served it with the declaration, they didn't submit it back, you have a better chance in court of really demonstrating that you served the proper paperwork. Next slide. This was, again, this is the landlord proof of service for the 15-day notice. This is what the process server could fill out, how they did it, by posting and mailing, by delivering it personally. So it's its own proof of service that you have your process server fill out. You can do it yourself, I know, but again, given how technical this is, putting a little bit additional money for a process server doing it right keeps the distance there in a way that that ensures that you're doing it and have completed it correctly. Next slide, please. This is again a notice of some of the rules that we discussed. Next slide. This is the informational notice that has to be given to anybody that hasn't paid rent through September 30th. And it really is a description of the rights of tenants. I would err, you know, again, depending upon how many tenants you have, you might want to just err on the side of giving it even if they haven't paid rent, if they paid rent on time, but that's a judgment call. There's no legal requirement to do it. Next slide, please. Again, I believe this is a continuation of the informational notice. Next slide. And this is the proof of service of your informational notice, very much the same as that would precede, but the same kind of thing that you would do with the 15-day notice for non-payment. Next slide. This is the slide where I mentioned where you have a federally backed mortgage, which incorporates both the 15 days notice to pay rent for somebody that didn't pay rent, plus the 30 days before they have to vacate because of the Federal CARES Act. The CAR has the form already. It's Form 403. Very nice. They've got probably 30 forms already generated by the new law. But again, a caveat, a warning, a disclaimer. And I should give a disclaimer. I'm not acting as your attorney today. We didn't have the slide. I should have had the slide here. I'm giving informational program here to you to follow. But if you want legal advice, you should retain me or another attorney for formal legal advice. This is really just for information to go off on to be informed. Next slide. Again, more about the informational notice. Next slide. Next slide, please. This was the declaration of the COVID-19 related financial distress. This is for those tenants that didn't pay going back to March 1st to August 31st. Again, this is the covered period for those tenants that if they never pay the rent, you can't use that as a basis for an eviction. It becomes something that you can claim in small claims after March 1st of next year. But they still have to declare that they were eligible for COVID relief. If they don't file that declaration, yes, then it could be the basis for a notice to pay rent or quit. But if they come within the protection and fill out this form, then that rent will be a consumer debt only, and it will never be the basis for a 3-day notice or a 15-day notice to pay rent or quit. And again, I would give them every opportunity of proving that they are unable to pay rent for any of the statutory reasons that are authorized under the CTRA. Next slide, please. Again, this was the 30-day. Also, for tenants that have failed to submit a declaration between March 1st and August 31st, after you gave them the informational notice for that period, they didn't submit a declaration. If you have a federally backed loan, you have to give the 30 days covered by the CARES Act. But again, I would not begin any evictions for any tenants for non-payment of rent, whether they gave you the declaration or not, and whether they paid the 25% rent or not from September 1st up through the end of the year because of the CDC guidelines. Would wait until next, not guidelines, CDC agency order that requires a ban on all evictions for non-payment. Next slide. Now we're ready for the Q&A.
Yeah.
Yes. Okay, so I did have some questions that's been posted on the chat
Sure.
box, and also I had collected some questions in advance. One of those questions is from Jessie, and she said, if not paying rent or partially pay rent, what impact on the credit and future rent possibility? I think it's from the angle of the tenant. If they're not paying rent or partially pay rent,
that's an
how would
excellent question.
it affect?
The AB 3088, the CTRA, has explicit protection of tenants that landlords are not supposed to report to credit agencies the non-payment of rent. So it's not supposed to impact their rent.
I see. Yeah. Well, I have another new question from Dominic, and he said, what should you do if the tenant owed rent before COVID?
They owe rent before COVID.
Yeah.
Again, because of the CDC guidelines, yes, you could go for a traditional 3-day notice to pay rent or quit for pre-COVID rent, but you cannot do it. Okay, let me answer it this way. If you had a tenant that didn't pay rent before COVID, they're likely didn't pay rent after COVID. So the COVID rules would apply even for the non-payment of rent that existed before. They would be entitled to whatever protection they had to be able to retain possession. So if you had a situation where they just paid 25% of the rent up through February 1st, then you, in my opinion, you couldn't go in for evicting that tenant for pre-COVID rent relief because they're entitled to rent relief during the COVID period. Whether you could then use it as a basis for a 3-day notice to pay rent or quit becomes a statutory question, which is if the non-payment of rent at that point was more than 12 months, then you couldn't use the 3-day notice to pay rent or quit as a basis for collecting that rent. You'd have to use it as a breach of contract action. If it was only for that period of time for the rent and somehow they magically got their act together, legally, could you do it? Probably not before January 1st. Not probably not. You couldn't do it under the CDC order until January 1st. But if you had a tenant that somehow magically missed a couple of months and fell short, but then somehow stayed current and was working with you, I would work with that tenant, okay, rather than try to evict them. If they have a good tenant history afterwards, it may have been a difficult time. So it depends upon the circumstances. But if there's been a continuum of non-payment of rent, then there's a question was, well, if they were fired before COVID and that's why they couldn't pay rent, it's not COVID related, maybe they can't submit a COVID related declaration. Well, I don't think a judge, I think you could in a narrow case prove that, but if they fill out the declaration under penalty of perjury, you'd have to prove that they're lying. And there may be other extenuating circumstances that they can't find other work, that the unemployment insurance is run out. So I wouldn't go back and say, well, gee, I've got this gotcha period of time before COVID. I'm going to use that and ignore all the protections for tenants, because we go back to the kind of the humanitarian concern that the courts and the public policy are going to err on the side of keeping tenants in their rental situations so that we don't have COVID transmission for people being dislocated from where they live.